this. You are assuming burden will be on the person seeking his removal to show that he was seeking publicity. It's premised on that. As a judge gets all the publicity, that's good for him. He should not seek more. So then it will be you are seeking publicity. In other words, you can't address bar councils. Yes, there'll be the media there. So what?
So they are not engaged in any public controversy.
No, it says least of all on a it's not the public, it says political question. Where is politics here? There's no politics here.
It says in particular, he should not engage in any public controversy. So if least of all on political matters.
Let's take the worst case scenario. If the institution he is in, there is corruption, he should keep quiet.
No, there is.
So what should he do?
He should be writing to the Chief Justice.
Okay, he says failed.
He should be writing to the
failed.
And if there is somebody,
then what should he do? He should keep quiet about it.
If there is someone approaching him, he has the power. He can issue contempt notice to that person. If anybody dares to approach him, to influence him in any of his decisions.
There's corruption, for instance, not this case, we are giving a simple thing.
What I'm saying,
and his colleague is taking a bribe. He writes to the Chief Justice, he informs the Chief Justice, doesn't do anything. He gets frustrated. Okay? Maybe the frustration level comes to a point that I'll go public now. Okay? So, fine. You can, the person against whom he is alleged and himself, you can certainly hold him to task by saying, prove this allegation. And the other person who's alleged it will say, you made a false allegation, I'll show it. Which is exactly what's happened in this case. So which other article can you rely upon?
This is the only article, I suppose, my Lord. There is an article which was invoked in the order itself.
Which one was that?
Kindly read second para of Article 2.
I'm going to read that. Right. Second para,
Second para of Article 2.
In the matter of taking his seat and of rising from his seat, he shall be punctilious in point of time, mindful of the courtesies, careful to preserve the dignity of the court, while maintaining an equal aspect towards all litigants, as well as lawyers appearing before him.
He should be careful to preserve the dignity of the court.
Yes.
Yes.
This is, my Lord, I think
you are saying it comes under this too?
Lord, what I'm saying is that these are the provisions which can be...
No, tell me which one.
My Lord, I said Article 5 and Article 2, subpara 2 also comes within that because, my Lord...
We have an advantage in having you before us.
My Lord, I'm grateful for
the advantage is you are now well versed with SJC matters. Okay. The other SJC matters where you are proceeding again. One is finishing a complaint, right? You don't have to inquire into great details of every frivolous kind of allegation. You can just dispose it off, consign it to the record or whatever it's called. But where you're proceeding against a judge, why you proceed against a judge? With a view to remove him. So you have to give him some... I mean, here you may be conflicted as a lawyer. I'm not saying conflicted in this case, because your contentions at other place may be different. You will say, establish this thing. Fair enough. The burden on whoever lies the burden will establish it or not establish it. It doesn't get established. Clean bill of health.
देखिए आर्टिकल 2 सब इसके सेकंड पैरा में लिखा है टू प्रिजर्व द डिग्निटी ऑफ द कोर्ट। जो एलिगेशन इन्होंने लगाई है वो तो डिग्निटी ऑफ कोर्ट के अगेंस्ट है, तो इसको प्रिजर्व कैसे करें ये आपसे पूछे। उन्होंने एक तकरीर में कर दी। दूसरा तरीका आप बता दें कि कैसे कर सकते हैं।
उसका तरीका मैंने बताया ना, जो एलिगेशंस लगा रहे हैं व्हाट इज again let me reiterate, I'm not taking sides. I'm saying if it can be stretched, that speech and conduct in terms of that speech can be stretched, it could at best fall within these articles, and there's nothing beyond that. Article 5 or at the sub-para 2 of Article 2. And this is for the Honorable Court to decide whether that speech, irrespective of whether it is based on truth or otherwise, comes up to that standard of falls within this mischief or not. That is all. As far as the inquiry part is concerned, that did not take place. So there were, and those specific allegations are not there in the speech. The order itself, when we read page 70, we read the conclusion, it is basically focused on the speech itself, which is said to be the reason why the removal is being recommended. It's not the question of any other issues that were raised there, because they were not inquired into. Yes, to the extent of the Honorable Chief Justice, the reply was sought, and that reply came, and whatever the Honorable Chief Justice said was against what the petitioner was contending.
Did the Chief Justice, was he examined?
No, he gave a letter. So it's all a question. If this is a matter which goes on to inquiry, then yes.
But then it will mean that there must be a standard why you are believing the Chief Justice and disbelieving a judge.
What I'm going to saying is, going back to the observation.
Is it the status which?
No, not at all. Not at all. It was just. I am not even supporting that. I am not supporting that because the Honorable Chief Justice said something, therefore believe him and not believe the other part. I'm saying if this Honorable Bench comes to the conclusion that in this matter, irrespective of the contents of the inquiry itself, the speech itself, and that it was made publicly addressed to a bar association, which was then, if this is fine, this is all right, this does not amount to misconduct, then the order that this Honorable Court has to pass, the way to move forward, is to exonerate him of the charges of making a speech which does not come within the ambit of misconduct. It does not imply that whatever he said was true or that it necessarily needs to be.
But if you read the order, it is 39 pages of the order.
Yes.
Content is there. If there was no content there, I mean, I would find it very strange that the mayor making of a speech.
I have submitted, my lord, that in the order itself there is a mixture of the presumption that what was being said by him in terms of allegations were not true, without an inquiry. I've already said that is part of the order itself. Okay. What the conclusion would be then, that this particular list would come to an end with the petitioner being exonerated of the charges, the order being set aside, the recommendation being quashed, and he gets whatever he gets. But beyond that, if this Honorable Court wants to go into whatever the petitioners, it has to go out of this list.
Khwaja Sahab, this nation has suffered enough. Now, it's not a question of granting relief to a particular person or withholding a relief from a particular individual. As far as I'm concerned, that's least of my concerns. My concerns are the integrity of the institutions. If the allegation level is true, I mean, the nation wants to know the truth of the matter. This person is telling the truth or that person is telling the truth. You say, no, forget it. Leave it aside. It's not a small matter of a small office holder post. It's a institutional matter. Let me ask you very candidly, as a senior lawyer, would you not want to know the truth of the matter, that the petitioner is telling the truth or your client is telling the truth? Just as you have invested your life in this profession. Yes, would you not want to know the truth of the matter?
This is exactly what I'm saying. I am with your lordship on that.
How do you get to it?
What I'm saying is that not in this list, not in the case before
how do we do it?
That your lordship takes suo motu action or takes some other action, but not it cannot be.
इनकी एक तजवीज़ आई है कि send it for review, remand it to the Supreme Judicial Council, that Article 209(7) was not complied with, and 205 and 6 all use the word inquiry, and 7 says you cannot remove it unless you follow the procedure. So that was not done. Without this court determining it, could the Supreme Judicial Council re-examine it and determine it once and for all whether, I think the nation needs to know whether the allegation is true or false. Leave aside your interest and his interest. There is an interest of the nation. You come from an institution which is paid out by the public exchequer. The petitioner comes from an institution which is paid out of the public exchequer. These institutions are not for your personal benefits. They are there to serve the people. So what do we do with it? People will make fun of it. What have you come up with? Result? who was telling the truth in this matter? Because the truth is diametrically opposed. He's saying one thing, you're saying the opposite. It's not a question of variation of the truth. He misunderstood me, I meant this. Then we could have maybe reconciled both versions. तो ये जरा बताएं, इसको solve करें.
जैसे गुजारिश की, what my learned friend has said, if he has proposed, if he is sticking to that the matter can go back to the Supreme Judicial Council.
Can it?
I see a legal impediment that the Supreme Judicial Council is not cut out, is not constituted, it's not part of the Constitution for the purpose of making an inquiry which does not involve the recommendation made to the President for removal or otherwise of that of a judge. That part of the function has already come to an end.
Are you then suggesting a complaint is filed against a judge, or as in this case by the registrar, whatever you want to call it, without inquiring into the complaint, Supreme Judicial Council says he is removed, recommends to the President, remove him. That's it. End of story.
The petition is here for the purpose of getting it quashed precisely for this reason.
नहीं, quash की बात तो नहीं आएगी. I'm saying that is the one person, but this is not a matter of one person. It's a matter of the independence of the judiciary, which the people of Pakistan have invested into it. They're not interested in a judge serving or not serving. This matter has gone into the public domain now. It has to be, the public has to be satisfied one way or the other. Who was telling the truth? Well, truth doesn't matter anymore. I keep emphasizing on truth. If he's truth, I think all the maslas will go away.
Just as it was open.
Aren't you personally interested just to know?
No, yes. May I make a submission?
Burning inside you.
But not within the framework of law, within the framework of Constitution, yes. We all want to know the truth, absolutely. But we have to remain within the frame. I do not see
which provision prohibits such an order. I'm just thinking aloud.
ये जो केस है आपके पास
नहीं ये ऐसी जनरल बात कर रहे हैं. अगर एक और कल को केस आ जाए, कंप्लेंट हमारे पास पढ़ने नहीं बहुत सारी पड़ी हुई है, आती जाएंगी, मुझे कोई जज नहीं पसंद है, चलो हटा दो इसको, सारे हमारे सुप्रीम जुडिशल मेंबर्स अग्री कर लें, हाँ हटा दो, कोई हम इंक्वायरी करें कुछ ना करें, आपको बस खत्म हो गई बात, अब कुछ नहीं कर सकते हैं.
पिटीशन आती है, एक पिटीशन.
अगर देखिए एक बात है substituting your opinion for someone else, that's a different matter. The other is inquiring into the matter. Even a murderer has committed murder in front of everybody, you still have to go through the process. I mean, even if someone commits murder right in front of 100, 200 people sitting in this room, we can't just say hang him. No, we'll have to frame a charge, we'll have to bring witnesses, we'll have to give an opportunity for cross-examination. Total waste of time, you will say. Yes, that's what rule of law means. Total waste of time. Sometimes it amounts to that. I'm just trying to, each decision creates a precedent. So where should we go now from here?
As I keep saying, my lord, the order gets quashed if dishonorable bench comes to the conclusion.
Then the nation will hold us accountable.
Necessary, notwithstanding the allegations made.
If you have finished, can we request the Attorney General? Huh?
Yes.
Okay.
I made my submission.
Have you understood, because you came in late, from what let's just quickly recap everything. The petitioner made allegations in a speech to a bar. One is, you shouldn't speak to the bar at all, end of story, go home. The other is that the speech was so, whatever, it was not pleasant for someone or the other, and nonetheless it was made. Now the content is either true or false. It is admitted on all sides that the Supreme Judicial Council did not inquire into the matter. The word inquiry, Khan Sahib has said, finds mentioned twice, 5, again in 2096, and 2097 says you can't remove it unless this. Okay? To proceed further, you have to inquire into the matter, not to finish a complaint. If the complaint was consigned to the record, that's not the issue. But when you are proceeding against a judge, then Khan Sahib has said, where is my due process? Where is my right to, if everybody comes before me asking for right to fair trial. Now we come to the situation, where do we go from here?
And the most important thing is that the allegation has been leveled against the institution, which is more important as far as I am concerned. ये इसकी तहकीकात होनी चाहिए या नहीं होनी चाहिए, सवाल में उड़ा.
और एक चीज और, ख्वाजा साहब has also said one more thing, something important. He said once he's been removed and he's attained the age of superannuation, the matter ends. Now, we were hearing some other case.
Yes.
The same issue came up there also.
So, my lord, as far as not following or not conducting the inquiry is concerned, that is contrary to law, and that to my mind would be malice in law, and therefore Article 211's ouster would not apply as far as this petition is concerned.
Which ouster?
211, sir. Article 211.
What does it say?
Bar of jurisdiction.
Bar on jurisdiction, my lord.
The number of judgments you said.
So I think that's quite settled. So if the inquiry hasn't been followed, on the basis of it being there being malafide in law, Article 211 does not apply. Therefore, this court would have jurisdiction.
Malafide in law.
No, but malafide in law is basically if the process is not followed. If what the law or the constitution requires is not followed, it is malafide in law. Not in fact, but in law. So because if that is so, then this court has jurisdiction, so the court can proceed. The court can look into this movement.
We are not a substitute for the Supreme Judicial Council.
Of course you're not, but the question...
We can't say, okay, now please come and give oath and give it on statement, will cross-examine.
No, this is jurisdictional question. This is jurisdictional question. You're not going to inquire into the matter while sitting as a court. The Supreme Judicial Council's, it is Supreme Judicial Council's remit to look into that matter, but I am just only saying that this court has jurisdiction to hear the petition if the inquiry has not been conducted, 209, and the procedure has not been followed.
That bridge.
So yes. So once that is done,
where do we go from here?
Once that is done, now one fact which was alluded to, and there is a judgment, a two-member bench's judgment in Afia Sheher Banu Zia's case, BLD 2023 Supreme Court 510, wherein the two-member bench has held that if a judge has resigned or has retired, the proceedings, while he was on the bench, had commenced before SJC, they would abate. Now, the federal government, I had in another matter stated before your lordship that the federal government intends to file an appeal against that judgment.
Has it been filed?
Yes, my lord, it has been filed.
What number hai?
My lord, it has yet to be numbered. I hope it will be numbered today or tomorrow. Now, there are several problems with that judgment, and of course...
If the principle of that judgment is sustained, then it effectively cuts both sides. Then a judge who's been unconstitutionally removed can do nothing.
Now, so in
the meantime, he retired, for instance.
So in this case,
he attained the age of superannuation.
So in this case, the distinction also is that after the petitioner was removed, he had essayed those proceedings before this court, and he had not attained the age of superannuation at that time. So that distinction being there, but that judgment needs to be revisited also by this bench or any other bench in order for the court to then pass the order of setting aside the Supreme Judicial Council's order in this case. Also,
yeah, I'm not clear with you. Are you saying that we should attach that case with this case?
I would submit so, my lord.
Achha. Okay.
And now, if the inquiry process has not been followed, and the allegation, now we don't know what
is remand permissible?
If, my lord,
if you are saying if Afia is sustained, then it probably may not be. Is that what I'm not understanding?
If Afia is sustained, then perhaps in this case, they may still have to, the petitioner may still have an argument to make, which is that he had not attained the age of superannuation when he had challenged the Supreme Judicial Council's order before this court. So there would be that distinction.
I think there is a fact is that the list in some form or the other was before this court.
That's right. So that's what I was alluding to. That if there would still be a distinction as far as this particular case.
If we accept this petition, what will happen? So we'll simply
two things can happen. If my lords accept this petition and simply set aside the Supreme Judicial Council's order without remanding it, then he would be treated as a judge who would retire.
We are also concerned about the allegations. What would happen to the allegations?
Suppose, with due respect to the petitioner and his counsel, suppose we set aside the order and he is laughing. All that I said was false. Okay? Nation, I think I'm more concerned that every case we decide we have to keep half an eye out that its implication generally kya hoga. You may want to do something, but it may have wide ranging implications. The other thing is, doesn't the nation want to know one way or the other? What is the position of the federal government on this? Wouldn't you want to, as they say, get to the truth of the matter?
My lord, so I just got called on short notice.
I know that's not fair.
What I can state here is that now there are certain allegations which are made in this petition, and those allegations, from what I've understood while sitting here, have been denied.
Not some minor allegations, some serious allegations.
Those allegations have been denied, and now obviously this court cannot record evidence. Is not the forum for doing it. Is there
a solution?
The solution, my lord, is that in order to look at the entire matter in totality, if Afia Zia is overturned and this matter is remanded to, the order of the Supreme Judicial Council is set aside and the matter is remanded to Supreme Judicial Council, then as far as the inquiry of these allegations is concerned, that perhaps is the only forum.
And then question arises that the man has retired. What will happen?
So for that purpose, you have to overturn Afia Shehrbanu Zia. For those purposes, you have to first, this court has to overturn Afia Shehrbanu Zia in order to cross that barrier and then go to the...
This case is slightly different. He was not retired at that time.
That's right. He was still before the court. Now the question would still be that if the petition is allowed, what could be the consequence? Now if limited consequences
जल्दी डिसाइड हो जाती है इनकी रिटायरमेंट से पहले तो मसला हल हो चुका
वो भी हो चुका होता, बट अगर फॉर एग्जांपल एक ये हो सकता है कि जी पिटिशन आप अलाउ कर दें एंड he is treated as a retired judge and thus entitled to all the benefits which a retired judge is entitled to. But if on a broader scale, so on a broader scale, then I think since he has retired and now that
is what's troubling me. Let's suppose a complaint is filed against a judge 1 month before his retirement. And the Supreme Judicial Council, without saying he's corrupt, Supreme Judicial Council, without inquiring into the matter, recommends to the President, reports, whatever, remove him. He's removed. Now, naturally, when he'll file the petition, he's already retired.
That's right.
So I don't think the date would there be, he has got no way to vindicate his honor.
There has to be a way.
Basically, you are saying one way is no, too bad, whether the Supreme Judicial Council inquired into the matter or not. I mean, whether we agree with the findings of the Supreme Judicial, that's a separate matter. One is at least inquire into the matter. Okay, I may have a higher level of proof, another may be lower, but leaving those technicalities aside, basic inquiry has to be conducted of some form or the other.
Absolutely.
I mean, whether it has to be in accordance with the Qanun-e-Shahadat or...
No, it's the Constitution requires so. I mean, a judge cannot be removed without inquiry.
Are judges entitled to fundamental rights or not?
Absolutely. I mean, it is at the heart of independence of judiciary. Absolutely. Absolutely. At the heart of independence of judiciary has.
इसका solution क्या है फिर?
So इसका solution, to my mind,
आप कह रहे हैं कि इसको क्लब करें उस केस के साथ?
उसको overturn करना जरूरी होगा because that would then settle the law. Because in this case, obviously there was a substantial period of time when the petitioner was removed.
लेकिन बात कहाँ से कहाँ connect हो जाती है?
And his
nobody could have thought this would connect there.
About 3 years.
So if he had 3 years to a service left.
No, लेकिन like I said, suppose he had only 1 day left.
Yes. So in that hypothetical,
I mean,
then obviously,
I don't think that's really crucial aspect.
So in that hypothetical, which my Lord has just pointed out, I think it is necessary that that point is settled. That the point is settled that even if he stands retired and attains age of superannuation, the matter can still be revisited by
because that delay we are accountable for in this particular case. Because it's proceeded so long. We can't fault the petitioner on that.
Oh, absolutely not. Nobody can.
So, कितनी hearings हो गई थी इसमें?
बेशुमार सर. Many hearings.
हमने कितनी दफा सुना?
Last hearing was.
मैंने कहा आपका इल्जाम हम पे तो नहीं है. हमने कितनी दफा सुना इस केस को?
ऑर्डर शीट. मैं आपको ऑर्डर शीट दिखाऊं.
ये दूसरी दफा है. हम मेरे साथी याद दिला रहे.
But we are responsible for our seniors.
अक्टूबर 2018 में ये पिटीशन फाइल.
2018
नहीं वो क्योंकि वो पार्टी नहीं बनाया था ना. उसमें भी टाइम लगा. वो आपका कसूर था खान साहब. थोड़ा हमारा कसूर था मगर वो आपका कसूर था मान लीजिए. क्योंकि आपने allegations लगाई थी against people who were not before us. So we had to give them a notice. So that goes in your. We don't accept responsibility for that.
But the question that even shows that this was a case.
Wasim Sajjad Sahab, can we benefit by your acumen? Have you been following what we are talking about? What is your view? Can it be remanded to the Supreme Judicial Council or not?
But actually, I haven't studied this matter. I wouldn't like to make a comment without going through studying it properly because it's an important question. But I would say that the Supreme Court of Pakistan is the highest court, and there's nothing in the Constitution which prevents it from remanding the case back to the Judicial Council. But as I said, I would like to study the matter further. Once the matter is before your Lordship also has the power to do complete justice under Article 187. So there is no impediment.
आपकी अपील कब लगी है?
My Lord, it's been filed earlier today. I think it will hopefully be numbered today. And once it is numbered, I think it can be fixed whenever the office will fix it.
Point that you want to say at this juncture? Anyone, any of the council or?
This is one of the exceptional cases. Earlier cases like Justice Shouqat's case, there was a detailed inquiry held. And after that, the Supreme Judicial Council submitted to the President to remove him. There have been even earlier cases, Ikhlaq Hussein's case, where inquiry was held. This is the first case of risk nature where no Supreme Judicial Council did not hold any inquiry into the allegations. So therefore, my submission is this goes right against the independence of...
No, can you cite those cases, the earlier cases, where inquiries were held?
One is Justice Shouqat's case is PLD 1971 Supreme Court.
1971 Supreme Court.
Page 585.
585. And here you are saying the Supreme Judicial Council did hold inquiry.
Hold a very lengthy inquiry, some 80 witnesses and so on. So
recommended the judge's removal. As in the next cases, this is Justice Shouqat Ali.
Earlier case was Justice Ikhlaq Hussein's case, PLD 1960 Supreme Court. Yeah, page 26 perhaps. अच्छा उसमें
नहीं वो पेज नंबर अखलाक हुसैन हम ढूंढ लेंगे, चलें खैर अगला वाला बताते हैं। कोई और भी केस है?
ये 2 केसेस हैं जहां पर सुप्रीम कोर्ट जज वाज रिमूव्ड आफ्टर ड्यू इंक्वायरी। अब सर एक और बात, 1956 का मैंने कॉन्स्टिट्यूशन देखा है, उसमें कहीं इंक्वायरी की रिक्वायरमेंट नहीं थी एज सच, बट inquiry was held.
Which was that provision of 56 Constitution? Which article?
Earlier article was 128.
128.
60, under the 60.
Article 128, Supreme Judicial Council, which did not specifically mention the word inquiry.
It mentioned inquiry. Article 128 was in the same terms as Article 209. But I'm talking about 1956 Constitution. Under the 1956 Constitution.
किसमें नहीं था?
ये इसमें नहीं था, अखलाक हुसैन वाले केस में, स्टेट वर्सेस अखलाक हुसैन।
नहीं, वो कौन सा आइन था जिसके आप जिक्र कर रहे हैं?
56 का।
उसमें नहीं था?
उसमें ये नहीं था कि इंक्वायरी जरूरी है।
उस आइन की कौन सी शिक थी?
उस आइन की शिक थी आर्टिकल 169। 169।
अच्छा 169। अच्छा इसमें नहीं था।
हाँ, उसमें
अब आप ये
I read that out.
No inquiry required. हाँ जी।
A judge of a high court shall not be removed from his office except by an order of the president made on the grounds of misbehavior or infirmity of mind or body if the Supreme Court, उसमें Supreme Judicial Council नहीं, Supreme Court ये function करते थे. If the Supreme Court on reference being made to it by the president reports that the judge ought to be removed on any of those grounds. ये Article 169 था उसमें, और इसके बावजूद भी डिटेल इंक्वायरी की गई थी उसमें, और डिटेल इंक्वायरी
अखलाक हुसैन का केस था तो 56 कॉन्स्टिट्यूशन वाज अंडर कंसिडरेशन और द 60 कॉन्स्टिट्यूशन
अंडर द 1956 कॉन्स्टिट्यूशन।
अच्छा, मगर उसके बावजूद भी इंक्वायरी हुई
थी। सो मेरी गुजारिश ये है कि दिस इज द फर्स्ट केस ऑफ इट्स नेचर वेयर ए जज इज रिमूव्ड विदाउट इंक्वायरी. It will have a repercussion for the future because judges of the Supreme Court has no other security available to him except that a Supreme Judicial Council makes inquiry into the allegations. If that is taken away from him, then he is left on the mercy of the person who alleges against him, whether he is president or whether he is any other person making a complaint. So therefore my submission is that a detailed judgment is required to give why inquiry is so necessary in cases where the allegations against the judge of the superior courts for which there cannot be any recommendation for removal without holding a proper inquiry into it and giving a statement of allegations. Even in the case of Akhlaq Hussain, there were 3 allegations, specific allegations there. Similarly, in case of Sheikh Shouqat Ali in 1971, specific allegations were made against him, on which inquiry was held. In here, no statement of allegations were ever given to the petitioner, and naturally.
और भी केस था ना वो खान साहब वाला
जी,
एक और भी केस था ना, वो रिपोर्टेड है या नहीं है?
ये दोनों केसेस तो
फजले गनी खान साहब का कोई उसमें केस चला था या नहीं चला?
चला नहीं था
इनका,
नहीं चला सर, नहीं चला। नो सर।
खान साहब एक बात बताएं आप, इसके अंदर तो एलिगेशन डिफरेंट है शौकत अली साहब वाले में और अखलाक हुसैन साहब वाले में। यहाँ पर जो इंफॉर्मेशन की बात है, सब सेक्शन 5 ऑफ आर्टिकल 209, वो इंफॉर्मेशन की बेसिस पे, लेकिन यहाँ तो सुप्रीम कोर्ट ने खुद कॉग्निजेंस लिया है, तो यहाँ तो कॉग्निजेंस लिया है इसने, वहां पे इंफॉर्मेशन किसी पब्लिक पर्सन ने, किसी ने कोई इंफॉर्मेशन तो नहीं दी है। तो इंक्वायरी उस सूरत में करी जाए जब कॉग्निजेंस लिया है कोर्ट ने, खुद लिया, रजिस्ट्रार ने दूसरा लेटर भेजा है, बिल्कुल उसकी बेसिस पे। तो ये चीज जो है यहाँ पे जरूरी है, इंक्वायरी बहुत जरूरी, जब कॉग्निजेंस सुप्रीम कोर्ट खुद ले रहा है,
और भी ज्यादा जरूरी हो गई है। जनाब ने बिल्कुल दुरुस्त फरमाया, और भी ज्यादा जरूरी हो गई है। हुआ ये था कि 1956 कॉन्स्टिट्यूशन में
तो ये केसेस में कुछ एक आध मेरे हिसाब से कुछ करप्शन का भी केस है इसका।
गुजारिश ये है कि इसमें हिस्ट्री की ये है कि ना 56 कॉन्स्टिट्यूशन में विदाउट प्रेसिडेंशियल रेफरेंस किसी जज को रिमूव किया जा सकता था, 962 के कॉन्स्टिट्यूशन में ये हो सकता था, 73 कॉन्स्टिट्यूशन में भी नहीं हो सकता। फॉर द फर्स्ट टाइम 17th अमेंडमेंट में ये लाए गए थे, द काउंसिल ऑन इट्स ओन, द काउंसिल में ऑन इट्स ओन मोशन। ये पहली दफा 2005 में इंट्रोड्यूस किया कॉन्स्टिट्यूशन में कि इवन सुप्रीम जुडिशल काउंसिल विल हैव द पावर ऑन इट्स ओन ऑन द बेसिस ऑफ a complaint available can proceed against a judge of the. This is the case here. It is not a case of presidential reference. It is a case with Supreme Judicial Council.
कैसे शुरू हुआ ये जरा में दिखाइए।
लेटर रजिस्ट्रार सर,
दोबारा ये बताएं कैसे।
क्या सुप्रीम जुडिशल काउंसिल ने क्या अपने तौर पे ये उठाया या
वो किधर
या रजिस्ट्रार ने एक नोट लिखा, रजिस्ट्रार ने किस कैपेसिटी में लिखा,
ये अपने तौर पे ना कंप्लेंट है,
ये वो दिखाएं
रजिस्ट्रार ने किस कैपेसिटी में दी, ये भी देखना है।
दिखाएं क्या चीज है
उसको।
39 पेज के ऊपर है ये, 39 पेज पे पैरा 3,
23/7/2018 को रजिस्ट्रार ने
ये पेज नंबर 39 ऑफ द पेपर बुक।
जी सर, ये है सर। यहाँ पर
अपॉन perusal of the note put up by the secretary of the council,
ये नोट किधर है, किस पेज पे?
नोट नीचे है सर दिया वो पैरा 3 में।
आपके कॉपी लगाई आपने? एक्चुअल
लगी हुई है।
जी कॉपी लगाई। इन्होंने खुद भी जो जवाब दिया है रजिस्ट्रार ने,
वो दिखा देना एक्चुअल नोट का है।
जी सर, ये 21/7/2018 ऑनरेबल मिस्टर जस्टिस सिद्दीकी एड्रेस।
नहीं, पेज कहाँ है? पेज कौन?
ये पेज 39 पे सर।
नहीं, ये तो उसका रिप्रोडक्शन है ना।
रिप्रोडक्शन है।
मुझ में एक्चुअल नोट दिखाइए मुझे।
एक्चुअल नोट हमारे पास तो नहीं है, ये हमें तो
ये रिपोर्ट से डॉक्यूमेंट फाइल किए, इसमें क्या है सारे ये जितने
अब उन्होंने जो
सर 73 पेज पे एक लेटर है अरबाब मोहम्मद आरिफ साहब का।
जी,
कंप्लेंट अगेंस्ट मिस्टर जस्टिस शौकत अजीज सिद्दीकी, जज इस्लामाबाद हाई कोर्ट, 31 जुलाई 2018 का है। जी हाँ।
आई एम डायरेक्टेड टू सर्व अपॉन यू द एनक्लोज। ये तो बाद में है ना।
कंप्लेंट जो इन्होंने रिसीव की है वो 23/7 की है, जो रजिस्ट्रार ने कंप्लेंट
मेंशन किया उसको रिप्रोड्यूस किया हुआ है, पेज नंबर 39 पे पैरा 3 में रिप्रोड्यूस किया हुआ है।
बिल्कुल सही, एग्जैक्टली वो रिप्रोड्यूस किया। The note put up by the registrar and the transcript of the speech. Note जो है, हाँ, ये note on top of page 39 on 21/7/2008 Honorable Mr. Justice Siddiqui addressed District Bar Association Rawalpindi. During this speech, he said,
39 के शुरू में सर,
page 39 सर,
ये पैरा 238 से शुरू हो रहा है।
page 39 के ऊपर जो फर्स्ट पैरा आप देख लिया।
नहीं, वो तो एलिगेशन है ना। जी,
एलिगेशन है।
अच्छा, नीचे पैराग्राफ 2 से पढ़िए
सर। ये पैरा 2 on page 38
जी।
On 23/7/2018 the secretary of this council, registrar Supreme Court of Pakistan, submitted the following note before the chairman of the council, Chief Justice of Pakistan. ये वो फिर नोट 23/7 को रखा गया। On 21/7/2018 Honorable Mr. Justice Siddiqui.
No, he was acting pursuant to a direction of the Supreme Judicial Council, or my lord has asked, Justice Jamal has asked that he did it himself. एक तो ना you do it. One is he does it, comes before the Supreme Judicial Council.
So it doesn't say so much, but it appears that there was some kind of.
We will go by the Constitution. Constitution says the council on its own.
On its own.
Secretary is not the council. He may be complainant.
It may be.
He's part of the. He's part of the Supreme Judicial Council.
Maybe the council had directed him to do it. I don't know.
Nothing is on record, कोई चीज नहीं है।
ठीक,
लेकिन ये
मतलब उसने अपने पर्सनल कैपेसिटी में दिया।
आप ये हियरिंग जो, अच्छा एक चीज बताइए,
आप जनाब पढ़ लीजिएगा।
कितनी दफा सुप्रीम जुडिशियल काउंसिल में ये केस लगा आपका? आप कितनी दफा सुप्रीम जुडिशियल काउंसिल ने आपको तलब किया?
एक दफा। Only on one occasion.
What happened on that occasion?
On that occasion, we said that please, in the first place.
No, why you asked something? Why were you called?
We were called to explain as a preliminary hearing before inquiry and preliminary hearing hoti under the.
Were you? Was the petitioner alone or was he assisted?
I was with him.
क्या हुआ सर, बताएं क्या हुआ था उस दिन?
उसमें यही क्वेश्चन हुआ कि ये क्या स्पीच की है आपने? वी मेड अ स्पीच व्हिच वी
नहीं वो ठीक है बस. So it was a casual, formal meeting. वो चार्ज फ्रेम हुआ आपके खिलाफ क्या?
कोई चार्ज फ्रेम नहीं है, कोई चार्ज फ्रेम नहीं है. बल्कि इससे पहले
we may need to see the record of the Supreme Judicial Council.
जरूर देख लीजिएगा. कोई कहा यहाँ भी कहीं रिपोर्ट में भी नहीं कहा गया कि कोई चार्ज फ्रेम हुआ है. रिपोर्ट में देख लीजिएगा ना, कहीं पर ये नहीं कहा गया कि मेरे खिलाफ कोई चार्ज फ्रेम हुआ, स्टेटमेंट ऑफ एलिगेशंस दी गई जिसका मैंने जवाब देना था. नथिंग ऑफ दैट सर.
आपको कोई शो कॉज नोटिस नहीं हुआ?
शो कॉज नोटिस दिया.
वो किधर है?
वो शो कॉज नोटिस
74 पे, 74 ऑफ द पिटीशन.
ये जनाब पेज
42 पर रिप्रोड्यूस भी हुआ है.
पेज 74 पर
इसका ये तो वेरेस अच्छा नाउ यू आर ये पेज 75 पे आ जाइए ना. ये ना
ये है जी पेज 75 पर. नाउ योर लॉर्डशिप आर हियर बाय कॉल्ड अपॉन टू एक्सप्लेन योर कंडक्ट विद रिगार्ड टू द फॉलोइंग एलिगेशंस व्हिच प्राइमा फेसी कॉन्स्टिट्यूट मिसकंडक्ट ऑन योर पार्ट विद इन द मीनिंग ऑफ पैराग्राफ बी ऑफ क्लॉज 5 एंड क्लॉज 6 ऑफ आर्टिकल 209 ऑफ द कॉन्स्टिट्यूशन. You were, while addressing the District Bar Association Rawalpindi on 21/7/2018, have leveled the following serious allegations pertaining to superior judiciary and a state institution.
देखिए इधर the question of seeking publicity नहीं allegation है.
ये नहीं है.
ये तो allegation वही है ना, substance पे जा रहे हैं state में. It's not अच्छा
making a speech and on the content of this speech actually.
पढ़ें that
ISI is fully involved in manipulation of judicial proceedings, including marking of cases to honorable benches. 2. That ISI personnel approached Chief Justice Islamabad High Court and asked him not to let Mr. Nawaz Sharif and his daughter come out of prison before general elections 2018 and not to include your lordship in the bench. And that Chief Justice Islamabad High Court responded that the bench will be constituted as per their desire. That your lordship claimed to even have knowledge of the person who conveys messages to the Supreme Court, that daily proceedings of accountability court were being reported somewhere, and that your lordship also knows the reason why the administrative control of Islamabad High Court as per statute was removed so that no judge could look into the proceedings, that your lordship was asked to give assurance that your lordship would give decision as per their request, and then references pending against your lordship would be closed. That if you
सुप्रीम कोर्ट में इस वक्त शौकत सिद्दीकी बरतरफी केस की समाअत जारी है. चीफ जस्टिस इसकी सरबराही कर रहे हैं. 5 रुकनी बेंच इस केस को सुन रहा है. इसके साथ ही न्यूज़ स्टूडियो से अब तक के लिए इतना ही.
किसी भी खबर की तफसील के लिए आप विजिट कर सकते हैं हमारी वेबसाइट bolnews.com. बाखबर रहने के लिए देखते रहिए बोल न्यूज़.
मेरे बाल आपकी तरह घने और मजबूत कैसे होंगे?
इधर आ. मेरी तरह बालों में प्याज लगानी पड़ेगी.
मुश्किल है. पहले छीले, फिर काटे, फिर इतनी देर तक लगा कर रखे.
हाँ, मेहनत तो बहुत लगेगी, पर इसकी नया लाइफ बॉय नेचुरली स्ट्रॉन्ग शैम्पू. इसमें है प्याज और एलोवेरा का स्पेशल फॉर्मूला. देख घने और 5 गुना तक मजबूत बाल.
एक
दूसरा है नरम मिजाज, पर अम्मी को नाज. ये जिद्दी दाग निकालते निकालते कपड़े तो खुरदुरे हो जाएंगे.
बिल्कुल नहीं. सर्फ एक्सेल का नया अलग अंदाज. ये जिद्दी दाग निकाले पर इनके सॉफ्ट पर्ल्स रखी कपड़े नरम और मुलायम.
सॉफ्ट.
सर्फ एक्सेल, दागों पर सख्त, कपड़ों पर नरम.
क्या आपको चाहिए शाइनी बाल? सनसिल्क ब्लैक शाइन में है 5 नेचुरल ऑयल्स के साथ विटामिन ई का सुपर मिक्स, जो दे आपके बालों को अप टू 24 आवर्स शाइन. अब बाल करें शाइन ऑल द टाइम विद सनसिल्क ब्लैक शाइन.
दुनिया के तमाम बड़े शहरों से बर वक्त पहुंचा रहा है हर खबर बोल न्यूज.
एक माँ ही बनाती है बेटी को सर से मजबूत, जड़ से मजबूत. लाइफ बॉय शैम्पू का मिल्क प्रोटीन और एलोवेरा फॉर्मूला बनाए इसके बालों को मजबूत. लाइफ बॉय शैम्पू, तुम मजबूत हो.
स्टार्ट कर
रास्ते घटाने वालों को, वतन चलाने वालों को उसाका बैटरीज का सलाम। आप हैं पाकिस्तान का बैकअप और हर मुश्किल में आपका बैकअप सिर्फ उसाका बैटरीज।
क्या आपको चाहिए शाइनी बाल? सनसिल्क ब्लैक शाइन में है 5 नेचुरल ऑयल्स के साथ विटामिन ई का सुपर मिक्स जो दे आपके बालों को अप टू 24 आवर्स शाइन। अब बाल करें शाइन ऑल द टाइम विद सनसिल्क ब्लैक शाइन।
दुनिया के तमाम बड़े शहरों से बर वक्त पहुंचा रहा है हर खबर बोल न्यूज।
मिलावट के साथ साथ आप तक पहुंचने में खुले दूध के अंदर जरासीम और गंदगी भी शामिल हो सकती है जो खतरनाक बीमारियों का बाइस बनती है। पैकेज दूध को क्वालिटी और सेहत के तमाम उसूलों के मुताबिक महफूज किया जाता है। पैकेज दूध सेहत महफूज।
खूबसूरत सा दिन है, नीला है आसमान।
एक माँ ही बनाती है बेटी को सर से मजबूत जड़ से मजबूत। लाइफ बॉय शैम्पू का मिल्क प्रोटीन और एलोवेरा फॉर्मूला बनाए इसके बालों को मजबूत। लाइफ बॉय शैम्पू, तुम मजबूत हो।
हुक्मरान चेहरों का तब्दील हो जाना तब्दीली नहीं, पुराने चेहरों का फिर लौट आना तब्दीली नहीं, घिसे पिटे नारे और बुलंदो बांग दावे भी कुछ तब्दील नहीं कर सकते। अदलो इंसाफ की बात करना एक कड़वा घूंट है। ऐसा लगता है सच भी एक झूठ है। तब्दीली वो है जो आवाम से फूटती हो, जो पाकिस्तान को मुस्तहकम, मजबूत और खुशहाल बनाए। तब्दीली जरूरी है। देखिए डॉक्टर दानिश के चुभते सवालात, तज्जिया और इंकशाफात। तब्दीली जुम्मा ता इतवार शब 10:03 पे सिर्फ बोल न्यूज पर।
Experience the luxury of Faez Sanitary, reinforced with a quality chrome coating, engineered for perfection, designed to give you superior water savings. Faez Sanitary for an elegant lifestyle.
ब्लीनी हेयर कलर, बाल डैमेज करता नहीं, स्किन पे चढ़ता नहीं। Be cool, be fun, be bold, be young. ब्लीनी हेयर कलर, हर रंग में लगो यंग।
इधर उधर दियां गल्लां च ना आ जाना, सिर्फ लासानी तूत स्याह प्लासम लट्ठी लेके आना।
मुझे आगे बढ़ना है, मुझे पढ़ना लिखना है, इल्म की राह पर हमको यूं ही चलना है। I love the educators, I love the educators, I love the educators, I love the educators.
The Educators,
a project of Beacon House.
शौकत अजीज सिद्दीकी के इल्जामात गलत हुए तो क्या होगा? टॉस करके तो सच और झूठ का तयन नहीं हो सकता। शौकत अजीज सिद्दीकी बरतरफी केस में चीफ जस्टिस के रिमार्क्स कहा, तमाम फरीकैन ने इल्जामात को मुस्तरद कर दिया। मसला एक शख्स को रिलीफ देने का नहीं, इदारों की इज्जत का है। इंक्वायरी कमीशन किस कानून के तहत बनाया जाए? क्या ये मुकदमा सुप्रीम जुडिशल काउंसिल को वापस भेजा जा सकता है? जज के तकरीर करने पर पाबंदी नहीं, ऐसा होता तो कई बार तकरीर कई जजेस फारिग हो जाते। चीफ जस्टिस सुप्रीम कोर्ट का मुकालमा, कहा मसला शौकत अजीज सिद्दीकी की तकरीर में उठाए गए निकात का है। अदलिया की बेतौकीरी का मामला कहां से आ गया? तकरीर में सियासत कहां से आ गई? शौकत अजीज सिद्दीकी ने शोहरत हासिल करने के लिए तो तकरीर नहीं की होगी, इसमें सियासत कहां से आ गई? कासिम सूरी मुल्क में आईनी बहरान की वजह बने, क्यों ना आइन शिकनी की कार्रवाई का हुक्म दिया जाए? चीफ जस्टिस सुप्रीम कोर्ट के इंतखाबी उज़रदारी केस में रिमार्क्स, कहा हुक्म इम्तना लेने के बाद मुकदमा समाअत के लिए मुकर्रर ही नहीं करने दिया गया। सुप्रीम कोर्ट के अंदरूनी सिस्टम के साथ हेरा फेरी की गई। गुज़िश्ता हिसाब लेकर रहेंगे, जिसने भी आइन तोड़ा है उसे नताइज भुगतना होंगे। स्टे ऑर्डर लेकर रुकनी असेंबली कैसे बने? दस्तावेजात के साथ जवाब जमा कराएं। लश्करी रईसानी और रजिस्ट्रार सुप्रीम कोर्ट की भी तलबी। आम इंतखाबात के लिए गैर मुल्की मुबस्सिरीन को इजाज़तनामे जारी, 49 वीज़े भी दिए गए, 25 दरख्वास्तें प्रोसेस में हैं। निगरान वज़ीर इत्तलात मुर्तज़ा सोलंकी कहते हैं इंतखाबात से मुतालिक क़यास आराइयों से गुरेज करना चाहिए। बैनुल अक़वामी मीडिया के नुमाइंदे पहले ही मौजूद हैं। सियासी जमातों की इंतखाबी मुहिम को टॉप गियर, नून लीग और पीपल्स पार्टी के आज भी बड़े पावर शो। बिलावल भुट्टो चिन्योट के हॉकी स्टेडियम ग्राउंड में जलसे से खिताब करेंगे। जलसागाह को पार्टी परचमों और बैनर्स से सजा दिया गया। शहबाज शरीफ अहमदपुर शर्किया क्रिकेट स्टेडियम में पंडाल सजाएंगे। मरियम औरंगजेब ने ट्वीट किया, शहबाज शरीफ महंगाई, बेरोजगारी, गुर्बत के खात्मे और मुआशी खुशहाली के एजेंडे पर इज़हार ख्याल करेंगे। मुल्क भर के बल्दियाती और कैंट बोर्ड्स के तरक्याती फंड्स मुंजमद। इलेक्शन कमीशन के मुताबिक फंड्स इलेक्शन की तकमील तक मुंजमद रहेंगे। बल्दियाती इदारे सिर्फ रोज़मर्रा के उमूर निपटाएंगे। इलेक्शन तक सफाई और सैनिटेशन का काम होगा। नई स्कीम का इजरा या टेंडर नहीं किया जा सकेगा। बानी पीटीआई ने तोशा खाना और 190 मिलियन पाउंड केस में जमानत के लिए इस्लामाबाद हाई कोर्ट से रुजू कर लिया। दोनों केसेस में जमानत के लिए अलग अलग दरख्वास्तें दायर। एहतसाब अदालत का फैसला कलअदम करार देने और केस के हतमी फैसले तक जमानत की इस्तदा। पाक ईरान कशीदगी में कमी, ताल्लुकात में बेहतरी। पाकिस्तानी एयरलाइंस ने ईरानी फ़ज़ाई हदूद का इस्तेमाल जुज़वी तौर पर शुरू कर दिया। टोरंटो से कराची परवाज़ का 37,000 फीट बुलंदी पर ईरानी हदूद का इस्तेमाल। इस्लामाबाद से दमाम की परवाज़ भी ईरान की फ़ज़ाई हदूद से गुजरी। दुबई इस्लामाबाद परवाज़ भी ईरानी हदूद से आई। सऊदी अरब से इस्लामाबाद और कराची से इस्तांबुल परवाज़ भी तेहरान से होकर मंजिल तक पहुँची। पाक अफगान तोरखम सरहदी गुजरगाह 10 रोज़ बाद तजारती सरगर्मियों के लिए खोल दी गई। अफगान ड्राइवर्स को सफरी दस्तावेज़ात के लिए 31 मार्च तक मोहलत। 1 अप्रैल से बगैर सफरी दस्तावेज़ात कार्गो गाड़ियों का पाकिस्तान में दाखिला ममनू होगा। अफगान कौंसिल जनरल और पाकिस्तानी हुकाम में मामला तय पा गए। तोरखम सरहद 13 जनवरी को तजारत के लिए बंद की गई थी। हमास का इसराइली दरिंदों पर भरपूर वार। खान यूनुस में इसराइली फौज के जेर कब्जा इमारतों को धमाके से उड़ा दिया। इसराइली हुकाम की इमारतों में 24 फौजी मारे जाने की तस्दीक। इसराइली हलाकतों की तादाद 224 तक जा पहुंची। गाजा पर इसराइली वहशियाना हमलों में एक ही रोज़ में 201 फ़लस्तीनी शहीद। शहादतों की मजमूई तादाद 25,295 तक पहुँच गई। इसराइली फ़ौज का खान यूनुस के अल अहल अस्पताल का मुहासरा। अल खैर अस्पताल का तिब्बी अमला यरगमाल। हेडलाइंस आपने मुलाहिज़ा की। आपको एक बार फिर से सुप्रीम कोर्ट लिए चलते हैं, जहां पर शौकत अजीज सिद्दीकी बरतरफी केस की समाअत जारी है।
क्या फैसला हुआ
जी?
डिसाइड क्या हुआ? डिसीजन
नहीं, उससे नहीं हुई। आई वॉज नेवर गिवन एनी हियरिंग। इसके बाद दी वन हियरिंग वाज इन कैमरा।
इसमें इशू तो ये है कि जहाँ तक तकरीर की बात है, आप तकरीर डिनाई नहीं कर रहे हैं। मालूम सिर्फ ये करना है कि ये मिसकॉन्डक्ट में आता है या नहीं, नंबर 1। इसका दूसरा एस्पेक्ट जो है, जो कि बार बार मैं इंसिस्ट कर रहा हूँ, वो ज्यादा इम्पोर्टेंट है कि वो जो एलिगेशन थी उसको मालूम करना चाहिए था दुरुस्त थी या नहीं थी। तो क्या सुप्रीम जुडिशल काउंसिल वो तहकीकात कर सकती है? सपोज अगर आज हम रिमांड भी करते हैं, तो क्या वो तहकीकात वहाँ हो सकती है या इसको कहीं और होना है?
हाँ, बिल्कुल इसमें इंक्वायरी होनी चाहिए थी। बल्कि पहला
कौन करेगा इंक्वायरी?
सुप्रीम जुडिशल काउंसिल को करनी थी ना।
नहीं, वो दूसरी एलिगेशन की जो इन्होंने एलिगेशन लगाई उसके बारे में क्या कहते हैं?
तो एलिगेशन ये
जो कह रहे हैं, जो कोर्ट्स पे जो बाकी रिस्पोंडेंट्स पे जो एलिगेशन लगी है, क्या सुप्रीम जुडिशल काउंसिल उस हद तक तहकीकात कर सकती है?
बिल्कुल कर सकती थी। और बल्कि मैंने ओपन हेयरिंग के लिए कहा था कि आप हमें ओपन हेयरिंग दें।
देखिए, शायद मैं क्लियर नहीं कर रहा हूँ। आप पे ये एलिगेशन तो नहीं है कि आप सही कह रहे हैं या गलत कह रहे हैं। आप पे एलिगेशन ये कि आपने जुडिशरी को मिलाइन किया, जो कि मिसकॉन्डक्ट में आता है।
ठीक,
वो तो आप मान रहे हैं कि तकरीर की सिर्फ ये देखना है कि आपकी तकरीर ज़मरे में आती या नहीं, लेकिन जो एलिगेशन है उसकी तरफ तो किसी ने तवज्जो नहीं दी कि वो एलिगेशन किस हद तक दुरुस्त है, किस हद तक गलत है।
उसकी
गलत है तो ही शुड फेस द कॉन्सिक्वेंसेज, और अगर दुरुस्त है तो रिस्पॉन्सिबल। लेकिन सवाल ये कि कौन करेगा?
लेकिन उन्होंने इंक्वायरी करनी थी ना इसमें। पहले तो मुझे स्टेटमेंट ऑफ एलिगेशंस देना था कि ये एलिगेशंस हैं इनका, इसको आप
कोई स्टेटमेंट ऑफ एलिगेशन
कुछ नहीं किया गया। सो गुजारिश मेरी ये,
सुप्रीम जुडिशियल काउंसिल इज अ वेरी पावरफुल बॉडी। आप जरा 210 भी पढ़ लें आइन का।
ये बिल्कुल सही है कि
जरा देखिए इसकी जरा मैंने अभी इसके जरा अल्फाज का चुनाव जरा देखिए।
Power of council to enforce attendance of persons, yes.
नहीं टेक्स्ट पढ़िए ना।
For the purpose of inquiring into any matter,
not pertaining to, it doesn't connect with the conduct of the judge. अब यहाँ widened up the scope. जरा पढ़े आगे।
Sir, वो इससे connected
नहीं जरा चले पढ़ते हैं आगे।
The council shall have the same power as the Supreme Court has to issue directions or orders for securing the attendance of any person or the discovery or production of any document, and any such direction or order shall be enforceable as if it had been issued by the Supreme Court. The provisions of Article 204 shall apply to the content powers. So
it's a very powerful body. It can call anybody.
That is what, in the context of inquiry, naturally, it has to be.
It's not hearing a case. It's inquiry. So वो आपने जो इंक्वायरी कमीशन की बात की, तो ये खुद ही इंक्वायरी कमीशन है इन अ वे।
बिल्कुल
more powerful than इंक्वायरी कंटेम्प्ट के पास भी इनके पास है।
बिल्कुल सही है। मैं इसीलिए कह रहा हूँ, मैं submitted, the answer is
खान साहब, let me put my anxiety to you. Every Supreme Judicial Council is not the Supreme Court. It's a separate constitutional body. Agreed? Every constitutional body should have maximum autonomy to decide matters. Agreed? Thirdly, we don't want to encroach or say or do anything. It just so happens that I'm a member of the Supreme Judicial Council as well, but we create precedent as well, that it undermines the Supreme Judicial Council. Supreme Court is not a watchdog over. However, like every other constitutional body, when a constitutional provision or a fundamental right is being violated by anybody or not being considered, let's both ways, then the Supreme Court is the only court which has the power, or the High Court, not in this case, to direct that this be done.
Yes.
So we have to be very careful how we proceed in this matter, because it will, like you are citing Justice Clark's case after 50 years, this will become precedent and it will be cited before us maybe earlier than 50 years. So we have to be very careful as to not disturb the perfect balance that the constitution makers have provided in the constitution.
There is an intervening judgment 2018 की, उसमें ये सारे एस्पेक्ट्स बहुत अच्छे डिस्कस हुए हैं, और उसमें ये आया उसकी हैसियत क्या है ये भी डिस्कस हुई है। मेरी गुजारिश है उस जजमेंट को जरा PLD 2018 सुप्रीम कोर्ट 538, I was counsel that case. Again, Shouqat Siddiqui's case.
This is Iftikhar Chaudhry's case.
This is PLD 2018.
वो अच्छा एक और जो आपका मैटर, नहीं ये नहीं का है, ये तो आप ही का केस है ना?
जी वही। इसमें ये एस्पेक्ट, प्रोसीजर एस्पेक्ट्स बड़े डिटेल में डिस्कस हुए हैं।
Which part you want to read from?
जी अब मैं आपको वो जो है ना पता है कि वो मेरे नोट्स निकाल लो, नहीं दूसरे वाले नोट्स में
पेज 5559 पे आ जाए।
538 से जनाब
पेज 5559 पे पैराग्राफ 51।
My lord, my lords, am I needed for these proceedings, or can I be excused for now?
Is there something urgent?
Yes, I have. There's a matter which I have to argue, not before.
Okay, fine, ठीक है.
But you must take note.
कोई बात हुई हमको बता देंगे. But you've noted the points, नहीं?
I have.
ठीक.
Sir, this judgment is very thorough judgment discussing various aspects of Article 209. पहला जो पॉइंट आउट करूंगा वो पेज 555 है। para 46.
जी.
Historically,
para 46.
Page 555.
Historically,
46. Historically, the fundamental rights of the people require protection from the excess of the executive and the vested interests, both commercial and political. In order to safeguard the fundamental rights of the people guaranteed under the Constitution, the independence of judiciary obviously must be insulated from the onslaught of the executive and such vested interests who are past masters at institutional capture. Thus, the security of tenure of judges, more so those of the superior courts, is imperative, and therefore adequate safeguards in this behalf are provided, including by enacting what appears to be a rather cumbersome and strict process of their removal. This cardinal principle is reflected in the constitutional dispensation of all the democratic countries, people by citizens and not subjects. The exception in this behalf are almost always found in...
Fine, you don't need to say this, it's obvious जी.
नहीं सर, एक ये बात जो एक बहुत important aspect है वो जनाब देखिए पेज 559 ये जरा पैरा 51 ये जरा जरूर देख लीजिए पेज 559 पैरा 559 पेज पैरा 51 the relevant provisions of the Constitution, more particularly Articles 209, 210 and 211, when examined in the light of the judgment handed down by a larger bench of this court in the case reported as Chief Justice of Pakistan Iftikhar Muhammad Chaudhary, and the previous pronouncements on the subject noted and quoted with approval in the aforesaid judgment, the relevant portions whereof have been reproduced in extenso herein above, should reveal that, firstly, the SJC is a unique forum created by the Constitution. Secondly, the SJC is not a court, though it may exhibit some of its trappings, including the power to punish for contempt. So it is not a court. Yes, year 2010 की judgment भी है. Thirdly, the proceedings before SJC are essentially a fact-finding inquiry, sir. This is what I am submitting here. This is the function of the SJC. Fourthly, the SJC is akin to a domestic forum and it conducts administrative proceedings regarding the question of conduct or capacity of a judge who is to be judged by his own peers. Fifthly, the findings of SJC are recommendatory in nature and do not enjoy the status.
So, yes, agreed. What is the point you want to make?
I'm trying to make here is a domestic forum. Your she was saying that it's just like as if it is some kind of a rival court to Supreme Court. No, it is a domestic body.
No, it is not. It's a constitutional body.
It's a constitutional body.
So, what happened in this case? Why did you come to court? What relief did you get or not get?
इसका primary function जो है वो inquiry है.
नहीं, ये फैसला जो आप साइड कर रहे हैं, ये क्यों आया आपका केस सुप्रीम कोर्ट में?
ओपन इंक्वायरी
केस क्यों आप लाए सुप्रीम कोर्ट ये वाला?
ये इसलिए कि हमने कहा था कि इस केस में कि हमारी ओपन इंक्वायरी होनी चाहिए.
तो सुप्रीम कोर्ट ने क्या फैसला किया?
सुप्रीम जुडिशल काउंसिल ने कहा नहीं, इट शुड बी इन फोरम. इस केस में
फिर तो आप ये ग्रीवेंस दोबारा एजिटेट नहीं कर सकते हैं ना हमारे सामने.
नहीं, बात क्या हुई, इसमें उन्होंने अलाउ कर दी ओपन इंक्वायरी. दिस जजमेंट अलाउड ओपन इंक्वायरी subject to certain conditions.
वो पैराग्राफ किधर है?
जी वो उधर भी आ जाएगी. It's a very historic judgment in that केस में
आप कहते नहीं अलाउ हुई
हैं?
सब SJC
कि क्या फायदा?
वो वापस भेजा ना सुप्रीम जुडिशियल काउंसिल 577 पैरा 96.
वो एक
Consequently, the question regarding the conduct of proceedings.
नहीं, तो ये तो वो रिमांड हो गया ना. ये केस रिमांड का केस है.
नहीं, इसमें उन्होंने कहा कि
नो आमिद खान साहब
सब्जेक्ट टू
हम जो इतनी देर से आपसे सवाल पूछ रहे हैं, ये पैराग्राफ 96 जो माय लॉर्ड ने पॉइंट आउट किया, पढ़िए.
नहीं वो ठीक है, उससे
आप पढ़िए तो.
सर बात ये है,
आप पहले पढ़ें तो ना 577 पे.
Consequently, the question regarding conduct of proceedings through an open justice as requested by needs to be revisited and decided afresh by ACG, not standing uninfluenced by its order dated so and so. जो order set aside उन्होंने किया.
आप पढ़े ना.
In the light of the observations made herein above. In the light of the observations.
So this is
observations क्या हैं?
एक सेकेंड
जी
सर, हमारी बात सुन लेना. अभी हम आपसे बार बार पूछ रहे थे रिमांड, तो ये रिमांड ही तो किया है.
पिछले सवालों का जवाब है
तो ये पहले सवाल का जवाब इधर मिल रहा है.
मैंने भी तो रिमांड ही मांगा है.
नहीं, अगर आपने बताया ही नहीं, आप कोई और वजह से बताया.
जजमेंट का मैं ये कह रहा था कि उसमें
फिर क्या किया सुप्रीम जुडिशियल काउंसिल ने इस ऑर्डर के बाद?
इस ऑर्डर के बाद उन्होंने अलाउ की थी. इन दैट पर्टिकुलर केस दे अलाउड ओपन हियरिंग.
वो ऑर्डर कहाँ है?
वो कोई दूसरा रेफरेंस था?
वो दूसरा रेफरेंस, वो रेफरेंस 242 है.
अच्छा, ये केस नहीं है.
जो इस केस में इम्प्यून था वो रेफरेंस 242.
लेकिन इस रेफरेंस की तो बेसिस जो है वो तकरीर है, और उस तकरीर को आप डिनाई नहीं कर रहे हैं, उसके कंटेंट्स को.
ठीक है, but then that has to be inquired into. तो मेरा गुजारिश ये करनी थी, जो जनाब के ऑब्जर्वेशन थी.
That reference was dismissed. What happened?
That was never decided.
You want that
proceeding stake of.
You want that be also be decided. आप चाहते हैं कि उसको भी डिसाइड करें?
नहीं सर, बिल्कुल नहीं. इसकी बात नहीं. मैं तो आपके सामने आपका प्रेसिडेंट दिखा रहा हूँ कि प्रेसिडेंट ये है. फिर उसमें इंक्वायरी के तरीका कार इसमें बड़ा अच्छा तरह डिस्कस हुआ है, वो भी जरा देख लीजिएगा. उसमें उन्होंने कहा कि ये जो इंक्वायरी होगी सुप्रीम जुडिशियल काउंसिल की, उनके ये पैरामीटर्स होंगे. मैं उसकी तरफ जनाब की तवज्जो दिला रहा था. वो तो आखिरी में उन्होंने कहा कि जी ठीक है, रिमांड कर रहे हैं आप, इस जजमेंट की लाइट में आप डिसाइड करें. परफेक्टली ऑल राइट. वो एक प्यारा था, उसमें कहा था इंक्वायरी में ये कुछ होना चाहिए.
तो खत्म.
जी सर. सो मेरी गुजारिश ये है कि all the judgment so far says that a judge cannot be removed on the basis of a report which is not based on inquiry, and this is a case without inquiry. The Supreme Judicial Council has submitted a report in which they have recommended the removal of the judge, and therefore that is clearly an unconstitutional void non-est order. About what Lordship was saying, उसके बारे में मेरी गुजारिश ये है कि प्रोसीडिंग्स में शोकॉट नोटिस हुआ एक, उसके 2 दफ़ा, पहला प्रिलिमिनरी रिप्लाई, फिर एडिड रिप्लाई, ये हुआ. उसके बाद एक एप्लीकेशन मैंने दी जिसमें मैंने कहा कि अगर अव्वल तो ये एड्रेसिंग ए बार एसोसिएशन इज नॉट ए मिसकॉन्डक्ट, बट इन केस यू वांट टू होल्ड इंक्वायरी प्लीज होल्ड इट इन ओपन कोर्ट. वो जजमेंट वो भी मैंने दिखा दिया. उसके बाद उससे 2 दिन बाद जब हियरिंग हुई, उसमें ये सारे सवाल आए और उसमें हमसे ये पूछा गया कि हाँ इंक्वायरी है, हमने बिल्कुल ये तकरीर की है, ठीक है.
नहीं, एक सेकेंड. सो देयर वर 2 रेफरेंसेस. एक में अलाउ हो गई आपका ओपन और दूसरे में नहीं अलाउ हुई.
नहीं, दूसरे में तो
आपने कहा था, आपने दरखास्त दी थी ना ओपन के लिए.
सर वो तो ओपन क्वारी का तो प्रेसिडेंट बन चुका था. ओपन क्वारी का तो प्रेसिडेंट हो चुका था.
अभी आपने कुछ देर पहले कहा कि उसमें इंक्वायरी ओपन नहीं हुई थी, मैंने रिक्वेस्ट की थी.
उसमें नहीं हुई.
तो एक में किया और एक में नहीं किया.
इसमें नहीं किया.
और फर्क क्या है दोनों में?
फर्क ये है कि आफ्टर इसमें तो इंक्वायरी सिरे से नहीं हुई ना. उसमें
नहीं, मैं अब इंक्वायरी की बात नहीं कर रहा हूँ. मैं अब कह रहा हूँ प्रोसीडिंग्स कि वो प्रोसीडिंग्स ओपन करें जी, वो इन कैमरा ना करें. एक में तो आपकी दरखास्त अलाउ हो गई.
जी
आप कह रहे हैं
बिल्कुल.
वो रेफरेंस नंबर 242 में. 242. मगर इस केस में इसका रेफरेंस नंबर क्या था?
मौजूदा रेफरेंस.
हाँ, इसमें आपने कहा नहीं हुई.
इसमें तो इंक्वायरी नहीं हुई सर।
या इंक्वायरी इज अ सेपरेट थिंग, ओपन प्रोसीडिंग्स की बात कर रहा हूँ।
ओपन प्रोसीडिंग्स देखो, ओपन प्रोसीडिंग्स इंक्वायरी की होनी थी ना, इसमें सिरे से इंक्वायरी नहीं हुई।
नहीं, वो एक अलग पॉइंट है, प्रोसीडिंग्स ओपन हुई या नहीं हुई?
एप्लीकेशन पे कोई ऑर्डर नहीं हुआ,
यानी जितनी प्रोसीडिंग्स,
इसका नंबर क्या है रेफरेंस का, ये वाली मौजूदा का
347,
ठीक है, समझ गया,
ओपन नहीं हुई।
खत्म। Can we ask Mr. Salahuddin? We want to wrap it up. Mr. Salahuddin, you've been hearing everything?
I apologize, I was not able to meet to Islamabad because of lack of availability.
What is the way forward? Address that point only.
My Lord, my submission is that the report and the notification is to be set aside on the ground of being malafide in law.
Please tell us the way forward.
Yes, sir. My submission is that it cannot be remanded to the SJC. The SJC scope is limited under Article 209. However, this court, if it considers fit, and I would urge that it
Who do you represent? Who do you
factual merit.
Take second, who do you represent?
My Lord, the Bar Association, Karachi Bar Association, and the
So you basically you don't want the truth to come out.
No, sir.
Yes.
In fact, my petition is.
You are saying. Please hear us. You are saying that the relief should be given to the petitioner, but the people of Pakistan should be kept in the dark because they can't handle the truth. So why can't it be remanded? Why are you saying it can't be remanded?
No, not at all, sir. I'm not saying that it should not be investigated. My submission is that the proper forum would either be this court itself or a commission appointed.
We are not seeking your opinion. We are seeking some legal response. In my opinion, that doesn't help us, does it? Why can't it be remanded?
It is because of the language of 209 itself, sir.
Where does it suggest that? In fact, Mr. Hamid Khan has just cited a case where it was remanded, the matter was remanded.
इसमें ये जो केस इन्होंने रेफर किया है इसको डिस्कस कराएं।
It cannot be remanded. If Mr. Shouqat's booking was still now,
we can't. Voice is gone.
48.
So the council to recommend his removal. Therefore, it does not have then the jurisdiction under 2096. So the remand right now cannot be done. It could have been done 2 years ago. But right now, the remedy is that, and certainly those allegations need
So you mean to say, on account, there is a well-settled principle that no one should suffer as a consequence of act of court. So you're saying because the court delayed the matter for 2 years, the petitioner's valuable right has been taken away from him. Is that your argument? We can't hear you. You're not speaking clearly. करें ना ठीक इसको.
That the civil servants actual tenure has ended.
Civil servant को आपने जज बना दिया.
नहीं सर, मगर
अब आप please don't.
Disciplinary proceedings ka principle to वही है sir.
No, it's not. Please, no, don't do this. If you're reducing a constitutional office to the level of a bureaucratic thing and saying the same principle applies, with respect, I will not agree with you.
My submission is that the stigma around the person's reputation caused by wrongful removal, that is something that he is entitled to remove, even if he has finished his age of service. It is the same principle which your lordships entertain appeals against convictions.